said yes. Separate schools denied children an equal education, even when the buildings and the books were identical. And that answer only deepened the mystery. If everything you could measure was equal, then something you could not measure was making these schools unequal. Here is where the story of this opinion ends, and where a harder one begins. On the 17th of May, 1954, a unanimous Supreme Court held that separate schools could never be equal schools. It overturned a doctrine 58 years old. It told a nation that the law it had lived by was wrong. The court had written that segregation could touch children's hearts and minds in a way unlikely ever to be undone. In the end, it said something close to the same of the law itself, that a wrong dressed in the language of equality was a wrong all the same. But a ruling is not a remedy. The court had named the injury. It had not yet prescribed the cure. And a system the law had spent 58 years building does not come apart simply because 9 justices in Washington declare that it must. How do you take apart a system the law spent 58 years building? That question, and a single fateful phrase, all deliberate speed, would wait for a second decision. The one the country would come to call Brown the Second. The court had answered the question it was asked. Whether separate could ever be equal, the answer was no. What came next it left for another day.